Good morning. That was the sound of a gavel. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, April 8th, 2020. The time is 9:30 a.m. And because we are conducting this meeting by teleconference, I'll begin with a roll call. Commissioner Lindley, good morning. Are you there?
Good morning. I am here.
And Commissioner Janeka, good morning.
Good morning. Also here.
And this is John Neerman speaking. So all of our commissioners are present. And how about our general counsel? Ms. Smith, are you there?
Yes, I'm here.
And our public interest counsel?
Good morning, Chairman. For the record, Vic McWhirter, Public Interest Counsel here.
Good morning, Vic. Since we're holding this meeting over a conference line, I'd like to remind folks to please keep your phones on mute when you're not speaking, and also to put your phones, not to put your phones on hold so that we're not subjected to the elevator music on hold. I'd also like to remind everyone who's not participating, that is, if you're listening but not speaking at the agenda, that you can also watch this meeting online. That link is available on the agenda notice, and the sound quality is quite a bit better. For each of the items where argument or discussion is allowed, we will inform speakers of their time limits. The registration to speak closed at 9:30, but if you'd like to address the Commission on a particular item, please email us with your name, your affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. The address, email address for those requests is agenda@tceq.texas.gov. It's agenda@tceq.texas, spelled out, .gov. For those of you who are making presentations, I'll ask you to please wait to begin until I have asked you to begin speaking. And finally, I want to thank everyone for being present. And since this is just our second telephonic meeting, we're still getting used to it. And I want to thank you for being patient if there are any problems along the way. With that, Ms. Smith, I'll ask you to call the first item.
The Commission will take up old business items 1 through 8 and new business item 1 together. Old business items 1 through 8 are the consideration for publication of and hearing on voluntary agreed orders with Southwestern Electric Power Company, LCRA, Luminant Generation Company, Energy Texas Power, San Miguel Electric Cooperative, Southwestern Public Service Company, Public Service Company of Oklahoma, and Texas Municipal Power Agency. New business item 1 is the consideration for publication of and hearing on a proposed state implementation plan revision regarding planned startup and shutdown emissions for certain electric generating units. The Executive Director's staff is here to present these items.
Good morning, and please introduce yourself and go ahead with your comments.
Good morning, Chairman. This is John Minter with the Environmental Law Division. Can you hear me okay?
I can, thank you.
Great. Okay. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am John Minter with the Environmental Law Division. Joining me on the phone for these items is Stephen Haygood with the Office of Air. For your consideration today are the Executive Director's proposed revisions to the State Implementation Plan, or SIP. Old business items 1 through 8 are voluntary agreed orders for several electric generating units that will establish certain operational limits and work practices for periods of planned maintenance, startup, and shutdown activities as federally enforceable emission limits. New business item 1 is the proposed SIP narrative for these 8 agreed orders, consisting of a demonstration that the SIP revisions will meet the requirements of Federal Clean Air Act, Section 110L, to ensure non-interference with any applicable requirement concerning attainment and reasonable further progress or any other requirement of the Federal Clean Air Act. The agreed orders and SIP narrative, if adopted, will be submitted to the United States Environmental Protection Agency as a revision to the Texas SIP. A public hearing will be offered on these proposed items in Austin on May 18, 2020. Due to COVID-19 restrictions, the hearing may be offered remotely on the same day and time. Staff respectfully recommends approval for the publication of and hearing on the proposed voluntary agreed orders and revisions to the state implementation plan. Staff also respectfully requests permission to make non-substantive revisions if necessary to comply with Texas Register requirements. Thank you for your consideration. We are available for any questions.
Thank you. I have none. Commissioner Lindley, any questions?
No questions.
Chairman, may I jump in? And I understand that there are a lot of conversations taking place on the public line that may be making it difficult for people who have called in to hear what's going on during the meeting. And again, I would ask everybody to mute their phones and be quiet so that other people can hear what's going on during this portion of the meeting. Thanks.
Thank you, Ms. Smith. And as a reminder for folks who are dialed in on the public line, if you're not planning on presenting, that is, you're not planning on speaking at the agenda, I would encourage you to log into the webcast that I mentioned at the top of my remarks. That website is available on the agenda notice, and the audio will be much better there. Ms. Smith, thank you for that note. Commissioner Janeka, did you have any questions for staff?
No questions for me, thank you.
Ms. Smith, are there any interested persons signed in to speak on this item?
We have one individual who was signed in but indicated that they didn't wish to address the commission unless there were questions, and their presence will be noted for the record.
Thank you. Public Interest Council, good morning again.
Good morning. For the record, Vic McWhorter, OPIC recommends approval for publication of all of these items as presented by the Executive Director.
Thank you. Commissioner Lindley, Commissioner Janeka, this package is carried forward from our last agenda to cure a potential procedural issue, but we're now ready to proceed on it. As we heard, EPA agreed with citizen petitioners that the current limits for EGUs at issue here as they relate to certain planned startup and shutdown emissions are not continuous limits as required under the Clean Air Act. And these 8 agreed orders and the SIP revision are meant to cure that by imposing operational limits and work practices that will constitute continuous enforceable limits. This appears to be a reasonable path forward. So I think we should publish the proposed orders and SIP revision and go ahead and take comments. And Commissioner Lindley, I'd like to invite your thoughts first.
I'm in a complete agreement. I think we should approve and move forward today as well.
Thank you. Commissioner Janeka?
Likewise, I'm in agreement and happy with moving forward. I think this is an acceptable attempt at answering a difficult question, trying to put some practical guide rails in place so that the public can be noticed for any changes in the future. Thank you.
Thank you. With that, I'll entertain a motion.
I will start, I guess. I move that we approve the publication of and hearing on the agreed orders with the following 8 power plants. Southwestern Electric Power Company, H.W. Perkey Power Plant, Lower Colorado River Authority, Sam Seymour Fayette Power Plant, Luminant Generation Company, LLC, Martin Lake Steam Electric Station, NRG Texas Power, LLC, Limestone Electric Generating Station, San Miguel Electric Cooperative Incorporated, San Miguel Electric Plant, Southwestern Public Service Company, Harrington Station, Public Service Company of Oklahoma. I've always pronounced it Oaklawn, but it might be Oaklawnian Power Station, and Texas Municipal Power Agency, Gibbons Creek Steam Electric Station, and that we approve the publication of and hearing on the proposed SIP revision regarding planned startup and shutdown emissions for certain electric generating units.
I second that motion.
The motion has been made and seconded. I'll call roll. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is consideration of the ALJ's proposal for decision and proposed order concerning the application of Bosky Solutions, LLC, for an air quality standard permit for a concrete batch plant, registration number 013. The protestants should go first, followed by the applicant, the executive director, and then Office of Public Interest Counsel. By letter dated March 20th, 2020, the Chief Clerk's Office, at the request of the Office of General Counsel, notified the parties that they will each have 5 minutes of oral argument time. The protestants may save time for rebuttal as they bear the burden of proof on this motion, and those who have signed in on this item but will not be addressing the commission will be noted for the record.
Thank you. And protestants, if you're ready, I'd ask you to please state your name for the record and go ahead and proceed with your comments.
Yes, good morning, Chairman and Commissioners. My name is Adam Friedman, and I'm representing the aligned protestants in this matter. I've advised them instead of calling in to view this on the YouTube channel, which they are all doing. And as we discuss this matter, and I'll try to keep it brief on the front end. It's pretty straightforward. We moved for a motion for summary disposition on the grounds that proper notice was not circulated to the presiding officer of Fort Worth. The Texas Health and Safety Code, Chapter 382, Section 382.0516B, expressly requires that if a facility of a concrete batch plant is going to be located within the ETJ of a municipality, the applicant, and really the TCEQ, is required to provide notice to the presiding officer. It's crystal clear. The legislative history makes it very clear that it's a critical requirement. It was adopted in the 90s because elected officials were being asked to intervene in these types of projects and these permit applications, but they were finding out that the elected officials weren't receiving notice of these, so they were having trouble getting involved, and that's why this requirement was adopted. And the TCEQ PI-1S, which is the form that's used when applying for a standard permit, it incorporated this language verbatim, in requiring that an applicant, represent to the TCEQ that the facility is within an ETJ, which then triggers the TCEQ to circulate notice. The one thing that the PI-1S does, in addition to the statute, is that the instructions indicate specifically that the mayor and the city manager qualify as the presiding officer, not somebody in the Department of Water or any other part of the city. It's the mayor or the city manager. And this application for the concrete batch plant submitted by Bosky is for a facility within Fort Worth ETJ. And it's undisputed that notice was not provided to the city manager or the mayor or the presiding officer for Fort Worth. The ED's staff testified in the deposition that they did not provide such notice because the application checked the box that said, no, we're not within an ETJ. So the Bosky Solutions itself, they put in their pre-file testimony that we did not provide notice to the TCEQ. We checked the wrong box. We made a mistake. And so I think the ALJ got this one right. Obviously, she's recommended granting our motion, and we support that, and we also support the recommendation that the application be denied and let Bosky refile for proper notice, because simply remanding the application for extended or reopening the public comment period isn't going to cure the defective notice. It's not going to allow Fort Worth to fully intervene and participate on behalf of its community simply by reopening a public comment period. There's some case law that suggests that reopening the public comment period doesn't authorize submission of contested case hearing requests. I think that the city of Fort Worth, should they choose to intervene and weigh in, they may want to seek to be a party. I don't think it's a foregone conclusion that they can't be a party. I think that the TCEQ rules allow local governments with statutory authority over abating air pollution can be an affected person. And so I just don't, the law, it doesn't suggest that simply reopening the public comment period would allow the Fort Worth, should they choose to weigh in, their full opportunity to intervene and participate on behalf of the community. And so the protestants are also recommending and would ask that the commissioners adopt not just the PFD's recommendation to grant the motion for summary disposition, but also the recommendation that the application be denied. And simply, the applicant can refile, can provide proper notice, can check the right box, and proceed in pursuit of the project in that manner. And with that, I'll yield whatever time I have left for rebuttal.
Thank you, Mr. Friedman, and I'd like to check in with our clerk to note how much time Mr. Friedman has for rebuttal.
He has about 20 seconds remaining.
Thank you. Commissioner Lindley, any questions or comments for Mr. Friedman?
No, not this time. Thank you, sir.
Commissioner Janeka?
Likewise, none for me, thanks.
Thank you, Mr. Friedman. We'll hear next from Counsel for Bosque Solutions.
Good morning, Chairman and Commissioners. My name is Derek Quick, and I'm here on behalf of the applicant, Bosque Solutions, LLC. We filed our written exceptions to the PFD, laying out several reasons why we think the ALJ was incorrect in recommending dismissal based on this notice issue, including because we don't think this is a jurisdictional provision. We don't think the protestants have any standing to complain about lack of notice on another party. We cited several cases for that proposition. And even if they did, we think they waived any complaint they had about it by continuing to litigate the case well after being made aware of this issue. We think at best this would have been considered a mandatory provision that can be waived. And in terms of the city of Fort Worth being denied the right to intervene, I think it's important to note that the city of Mansfield did try to intervene in this case and was denied because they didn't meet the statutory requirements. The legislative history was cited as to suggest that would somehow give the official the right to intervene, but we noted in the exceptions that legislative history was actually for the subpart A of that provision and really had nothing to do with the subpart B, which was added in 2007. So I don't think there's been any authority cited to suggest the city of Fort Worth would be allowed to intervene, and so we think any potential harm to the city would be speculative. But if the commission is inclined to agree that the ALJ was within her discretion to reissue this notice, we do think it would be appropriate to send the case or to go with the recommendation of the executive director, where the application and draft permit would be remanded to the executive director so that the required notice could be provided to the city, and then the comment period would be reopened for 30 days. We think the recommendation to deny the application entirely and make a start over from scratch would be an unnecessary waste of resources. I think, particularly given everything that's going on, I think that burden on the applicant to completely start over wouldn't serve any purpose, and it would just, again, waste a lot of resources that is not needed, particularly given the particular notice issue in this case. So we'd ask that you'd go with the executive director's remand proposal. If you have any questions, I'm happy to answer them. That's all I have right now.
Thank you, Mr. Quick. Commissioner Lindley, any questions?
No, not this time. Thank you.
Commissioner Janeka?
Nothing in particular other than just to ask if there's been any internal review and review to the inaccurate information initially provided on this question. Have you looked at your process for review of the application documents to try to avoid mistakes like this or omissions in the future?
In terms of my understanding of how this issue came about, this property is kind of interesting in that it's much closer to the city of Mansfield. The city of Fort Worth has a very large ETJ, and I believe the property turned out to be on the very edge of the ETJ. And the consultant, when he was reviewing, I think went to the specific ETJ for the city of Mansfield and not the city of Fort Worth. In terms of correcting this in the future, I can't speak to what process they've changed, but I imagine there's going to be amendments to that process.
Thank you. No further questions.
Mr. Quick, thank you. I appreciate that. We'll hear next from the Executive Director's Office.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I am Amy Browning of the Environmental Law Division, representing the Executive Director. With me on the line and also available to answer questions are Betsy Peticolas of the Environmental Law Division and Don Nealon of the Air Permits Division. The Executive Director respectfully recommends the Commission remand the application of Bosky Solutions, LLC for registration for a concrete batch plant standard permit to the Executive Director to allow the notice issue identified in the Administrative Law Judge's proposal for the decision to be remedied. This would allow the Executive Director to send the required notice letter to the City of Fort Worth, reopening the comment period for 30 days and make any necessary changes to the response to comments should new comments be submitted. Thank you, and we are available for questions.
Thank you, Ms. Browning. I have none. Commissioner Lindley, any questions?
No questions. Thank you, Amy.
Commissioner Janek, any questions for staff?
None for me, other than what efforts or what looks have we taken to try to ensure that this omission or this mistake is caught in the future in other applications.
Good morning, Chairman, Commissioners. This is Don Nealon. I'm a permit reviewer for this application. And what we're doing is when we get a site that's close to a city, we'll also look at the larger metroplexes and make sure their ETJ doesn't fall down on top of that site so we can notify everybody properly.
Thank you.
Thank
Chairman,
you.
Before we move along, I'd like to just remind again on the public line if to please mute your phones so that people can hear the discussion. Thank you.
Thank you for that, Ms. Smith, and I'll be redundant here too, and just invite folks who are on that public line who don't intend to speak at the agenda to try watching us on the webcast. The sound quality is better there. I'd like to thank staff for their presentation, and we turn next to Public Interest Counsel.
Thank you, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. I'm going to take just a second and ask, can you guys hear me okay?
I can. Thank you, Mr. Wayne.
Okay, perfect. Thank you. Thank you very much, Chairman. As background here, all parties do agree that the application did incorrectly state that the facility would not be located in a municipality or the extraterritorial jurisdiction, the ETJ, of a municipality. Further, it's undisputed that this facility will be located in Fort Worth's ETJ. Relying on the information that was contained in the application, TCEQ didn't send notice of the application to Fort Worth's presiding officer in violation of the Texas Health and Safety Code, Section 382.0516B. Procedurally, both the protestants and the applicant filed motions for summary disposition, and on January 17, 2020, following a pre-hearing conference during which the motions were considered and oral argument heard, Administrative Law Judge Summer Hayes granted protestants' motion for summary disposition. On February 14th, ALJ Summer Hayes issued her proposal for decision recommending that the Commission deny the application or alternatively allow Bosky to amend the application and provide proper notice. By letter dated April 6th, the ALJ recommended that no changes to her PFD be made in response to filed exceptions. OPIC has considered the arguments presented by the parties and the ALJ's PFD. OPIC does acknowledge that the applicant has made some compelling arguments regarding whether this particular notice provision is jurisdictional and whether the protestants lack standing to raise this specific issue. For OPIC, however, we're unable to disregard that the applicant caused this notice defect by filing an inaccurate and incomplete application. We all now know that the application is deficient and needs amending to state the facility is in Fort Worth ETJ. And as a result, we all now know that a statutory requirement for notice was not met. Therefore, OPIC recommends that the Commission request that the ALJ leave the pending proceedings open but abated. remand the application to the executive director, and require the applicant to renotice the application, including publication of the consolidated notice of receipt of application and intent to obtain permit, and notice of application and preliminary decision. Further, the applicant TCEQ should send notice to the presiding officer of Fort Worth as required by Section 382.0516B. The comment period would be reopened. OPIC does not believe that the comment period can be opened only for Fort Worth. All interested persons would have a right to know the comment period is open and when it would close. If additional comments are received, the ED would amend the response to comments, mail it out, and allow for the filing of additional hearing requests. Any new requesters could then be referred to SOA to allow the ALJ to determine if the requester is affected and how they may participate in the hearing as it resumes following the abatement. This solution would ensure the known inaccuracy in the application is corrected and the known statutory notice defect is also corrected. It would avoid the untenable alternatives of either granting the PFD and denying the application or otherwise allowing the application to move forward with a known inaccuracy and statutory notice defect. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Commissioner Lindley, any questions?
No questions. Thank you, sir.
And Commissioner Janeka?
None for me. Thank you.
Thank you. Thank you, Commissioner Janeka. And Mr. Friedman, you've got just a little bit of time for any rebuttal you might want to offer.
Sure. Thank you, Chairman. Obviously, I can't get into the weeds of all of the arguments, but, they were all briefed and rejected by the ALJ. And the only other thing I would say is that the reopening the public comment period, if that is the direction that the Commission chooses to go, it just would seek some clarity on whether that would allow requests for contested case hearing, which the rules certainly provide for the City of Fort Worth as a local government with authority to enforce abatement of pollution. And with that, again, I would urge the Commission to adopt the PFD for both granting the motion and denying the application. Thank you.
Thank you, Mr. Friedman. Commissioner Lindley, Commissioner Janeka, as we heard, TCEQ failed to provide notice of this application to the presiding officer of the City of Fort Worth, as is required under Texas Health and Safety Code, Section 382.0516. The agency's omission was due to the applicant's representation that the proposed facility would be sited outside of the city's ETJ, and that's not correct, as it turns out. So we three are now asked the significance of this failure. The administrative law judge granted summary disposition and recommends that we deny the application based on her conclusion that Fort Worth is entitled to intervene as a party. And that conclusion is, in my view, incorrect as a matter of law. While cities can be parties on certain types of air permits, in this case, the city cannot be a party because it is not a person residing in a permanent residence within 440 yards of the proposed plant. And I'm referencing the statutory requirement at Section 382.058C. In addition, this notice defect is not jurisdictional. Under a pair of cases, the City of DeSoto versus White and TCEQ versus Denbury Offshore, there has to be clear legislative intent to overcome the presumption that such notice defects are not jurisdictional. And I find none. I note, too, that the difference between informational notices to elected officials and notice to potential parties is significant. Those are two different things. Finally, because the notice is not jurisdictional, the protestants lack standing to raise it. The protestants have fully participated in representing their own interests, but have not alleged any personal injury resulting from the failure to notify the presiding officer of Fort Worth. And I'm not sure there could be any personal injury for that failure. So, colleagues, I'm going to, I think remanding to the executive director is necessary. It adds quite a bit of process and administrative burden to no productive end. I'm going to move that we remand this matter to the State Office of Administrative Hearings and direct the administrative law judge to continue with the hearing on the merits. And with that motion pending, I'll open it up for discussion. Commissioner Lindley, do you have any comments?
I really can't add anything substantial to what you just said. I'm in agreement. I wrestled with this one a little. I do think it's a challenging decision for us, but where you landed as far as remanding it to SOA, I'm in agreement with, and really looking at my notes for the same reasons. I don't think you said anything I didn't have jotted down, and I don't have anything different to add. You know, I'll just stop there. Yeah, thank you.
Okay, thank you, Commissioner Lindley. And Commissioner Janeka, I'm happy to hear your thoughts on this, and if you think it's appropriate, I'll invite you to second the motion.
Thank you very much, Chairman. And Commissioner Lindley, I think it sounds like we're all three in agreement. I too wrestled with this some, and I believe that there should be some consequence for inaccuracies in application materials. However, in this instance, I think a remand to the executive director really would be a foregone conclusion in as much as the statute is pretty clear. I agree with your analysis, Chairman, that there is no possibility for the city of Fort Worth in this particular matter to intervene as a direct party. So I think it would be a waste of resources to remand to the executive director. And in as much as there do need to be consequences, I will merely observe that we're here today and at some delay to the final issuance or final decision on this particular matter. So that may be a consequence enough in this instance. It is not the best solution abounding, but in the circumstances we find ourselves in today, I think it's certainly appropriate. And I'll wrap that up and just say that I will second your motion, Chairman, unless Ms. Smith would like us to succinctly restate that motion.
Ms. Smith?
No, I think the motion was succinctly stated the first time.
Good. Then I second.
Thank you, Ms. Smith. Thank you, Commissioner Janeka. The motion has been made and seconded. I'll call roll. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, I'll ask you to call the next item. Ms. Smith, how are we doing?
I am still on the line, but I think we may have lost Commissioner Janeka. I can't hear him.
Sorry, I'm here. Were you asking for votes? I'm so sorry. I was turning away from my computer.
We're waiting for Ms. Smith to call the next item, item 3.
Okay, I'm sorry about that. I think my phone lost hearing for a moment.
Why don't we check in and just take a quick roll call, make sure we have the necessary parties here. So, Ms. Smith, I hear you. Commissioner Janeka, I hear you. Commissioner Lindley, are you still on the line?
Yes, I'm here. Thank you.
And we have our Public Interest Counsel.
Yes, Chairman, I'm here.
Great. Okay, I think we can go ahead and proceed when you're ready, Ms. Smith, with item 3.
Okay, item number 3 is the application by DDR Rock Ranch Partners, Ltd. to amend Certificate of Adjudication number 191160A. The parties have been notified that the Commission will not take oral argument, but may ask questions. The presence of those who have signed in on this item will be noted for the record.
Thank you, Ms. Smith. And colleagues, 2 of our hearing requesters have asked for more time to brief this matter. As I considered this, I recognize the fact that this matter was originally set for our last agenda, so they've already had, in effect, 2 additional weeks. Also, this matter has been ready for agenda since April of last year. but it's been held back to allow time for mediation. I think the relevant issues are clear on the existing briefing and would propose that we move forward today with an agenda rather than to grant more time, and wanted to ask if either of you had any objections to that. Commissioner Lindley?
I do not. I'm in agreement.
And Commissioner Janeka?
Likewise.
All right, so for the benefit of those who are unfamiliar with our process on requests for contested case hearings, we have a two-part analysis. First, we consider whether the requesters have met both the procedural and substantive requirements to be entitled to a contested case. And then, assuming at least one requester has met the requirements, we consider which issues are appropriate to refer for hearing. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the type of authorization at issue, and have done so both in timely comments and a timely hearing request, are entitled to a hearing. The authorization in this case is a certificate of adjudication for a water right, and we have three requesters: Ms. Coleman, Ms. Savage, and Mr. Pollack. Neither Ms. Coleman nor Ms. Savage hold a water right or have otherwise demonstrated an interest not common to members of the general public. Mr. Pollack appears to have had a personal justiciable interest with respect to his reservoir. However, the draft permit, the draft authorization was modified to specifically exclude the reservoir. Therefore, Mr. Pollack no longer has personal interest. So I agree with the Executive Director and the Public Interest Council that we should deny these hearing requests and go ahead and grant the amendment to the certificate of adjudication. And Commissioner Lindley, I'll invite your thoughts now.
I'm in agreement as well. I appreciate how you laid that out. Thank you.
Commissioner Janeka?
I think that captured all the relevant pieces. I concur.
Thank you. I'll entertain a motion.
I would make the motion that we deny all hearing requests and issue the amendment to Certificate of Adjudication number 19-1160A to DDR Rock Ranch Partners Limited as recommended by the Executive Director.
A second.
Do I hear a second? Thank you, Commissioner Lindley. I hear a second. The motion has been made and seconded. I'll call roll. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the application by DTB Investments LP for a major amendment of Texas Pollutant Discharge Elimination, TPDES permit number WQ00150920001. The parties have been notified that the commissioners will not take oral argument but may ask questions. On this item, we have representatives from the applicant and over 30 hearing requesters who have signed in and indicated that they are available if the commission has questions. Also, Mr. Lawrence Bailey, on behalf of Representative Biederman, is present, and their presence will all be noted for the record.
Thank you, and good morning, Mr. Bailey. Thank you for being here, and please thank Representative Biederman for his interest and work on this issue. As I mentioned earlier, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements for being entitled to a contested case, and then we consider which issues are appropriate to refer for hearing. So part 1 is about who gets the hearing, and part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant on this application. So colleagues, we have over 30 requesters in this manner, and I'm going to recommend that we do grant some and deny some. I'll lay out my analysis and would invite you to interrupt me as we go along. Might be more efficient than trying to observe your questions, but feel free to interrupt me if at will. Let me put it that way. So the first hearing request we'll take up is that of Representative Kyle Biederman. Representative Biederman's request is based on concerns about his constituents' property. I'm unable to find that he has shown a personal justiciable issue, so I think we're compelled to deny his request. Next, we have two associations. The Bulverde Neighborhoods for Clean Water has timely filed comments and a hearing request that articulates issues relevant and material to this permit and that are germane to the purpose of that association. It has also identified members who would have standing in their own right, so I think we should grant its request. The second association, the Greater Edwards Aquifer Alliance, has failed to identify a member who has standing in his or her own right, and fails to adequately explain this lack of identifying a member in its reply. And I think we need to deny this request, as well as the request for reconsideration that was made on that particular issue. Turning to the individual requesters, there are several who failed to file timely comments. These are James Allen, Barbara Allen, Danny Batts, Gerald Cosgrove, Nancy Harkins, William and Peggy Huber, Nicholas Lewis, Nancy McKee, Laura Christine Pegas, and Seth Prescott. And for those folks, because they failed to meet the procedural requirements, we have to deny their request. Next, we have requesters who don't reside near any part of the proposed facility, and that includes Aaron Cantu, Michael Maurer, and again, Seth Prescott. And especially given the very restrictive discharge limits here, these requesters are not affected in a manner different from the general public, and so we need to deny these requests as well. Next, I'll identify several requesters who do reside near the proposed treatment plant and have articulated personal justiciable issues in timely comments and hearing requests. And these are Adra Lee Anzalata, Scott Barnes, Joseph Brockman, Margie Brockman, John Courtney, Lindsay Fitzsimmons, Julie Goss, Mary Lou Jenkins, Agnes Mary Clark, James Clark, Elizabeth Clark, John Lavin, Ann Lynette Lavin, Annette Lewis, Peter Lewis, Benno Lukes, Shannon Scott, Brett Winkler, and Lori Winkler. And we should grant then their request. They have met both the procedural and substantive requirements to be entitled to a contested case hearing. And
Chairman, I just want to...
Yeah, go ahead. Go ahead.
I was checking those names as you were reading, so I think I got everyone, but I think I might have missed two towards the end. Did you list Mr. Benno Lux? L-U-X?
Yeah, I identified him as meeting
Granting.
all of the requirements, and so I would grant his request for a contested case hearing.
I agree. And in that same list, did you also say Shannon E. Scott?
Yes.
Okay, just double checking. Thank you.
Yeah.
I agree on those names you listed.
And I apologize if I read those too quickly. I'll try to be mindful of that. So that leaves us with 19 requests that I have not yet addressed. And these 19 have all articulated relevant and material issues. They've done so in timely comments and timely hearing requests. The question for me is whether they live near enough to the facility to have an interest that's not common to the general public. And this is where we have a little wrinkle. Unlike most wastewater treatment plants where the discharge point is effectively co-located with the treatment plant. In this case, they're separated by over a mile. It's about 1.25 miles. And the 19 remaining requesters reside within approximately 1.5 miles of that discharge point as the crow flies, but none have riparian property downstream of the discharge point, and none are near the treatment plant itself. So what do we do about this somewhat unique fact pattern? You know, we don't have a bright line distance from a facility that demarcates where a person's interests become indistinguishable from the interests of the general public. These are case-by-case determinations. They depend on a variety of factors, including site characteristics, likely impacts, the issues raised in hearing requests and comments. And so the radius may be smaller for a small plant, for example, and larger for a larger one. Radius might not even be the right term because the demarcation is not necessarily a circle. But in any event, a discharge point that is separate from a treatment plant has much less of an impact on its neighbors than the treatment plant itself. So, you know, I think about, in fact, clear treated water might even be considered an amenity. So it follows that the distance at which personal interests become indistinguishable from the general public is going to be shorter. A smaller map for a discharge point that's discharging treated water, that standing alone, that distance is going to be smaller. And maybe even that distance is zero. We might find no impacts at the discharge point. I think that's a reasonable framework to think about this. And just to be clear, the effect of that argument as we shrink the radius is to increasingly exclude the 19 remaining requesters, even up to the point where none are left. And they're sort of scattered from, you know, roughly 1/3 of a mile out to 1.5 miles from this discharge point. The recommendations of the executive director and OPIC apparently have not distinguished between the impacts of the treatment plant and the impacts of the discharge point. And they have effectively 2 radii, one for the plant and another for the discharge point, that are about the same. And so they recommend granting all 19 of the requests, I think is how I've read that. But in any event, they have identified, you know, 2 essentially circles around, one around the plant, one around the discharge point, that are roughly of the same dimensions. And in my view, because the discharge point impacts are much less than the treatment plant impacts, I don't think that's the right result. I can't see how a person who resides over a mile uphill from an outfall for treated water would be affected in the same manner. Would be affected in a manner different from the general public. And I think that's especially true here, where the permit limits are as restrictive as they are. There's counter-argument. On the other hand, the discharge point is located in the Edwards Aquifer contributing zone, and commenters have expressed concerns about their groundwater. So we need to find the right balance in here. And in looking for guidance, I think one source of guidance is borrowing, even though they're not applicable in this case, but we can borrow the logic behind our land application rules that require information on groundwater wells within 1/2 mile of the proposed activity. You know, that is I think a reasonable reference point, and lacking any other guidance or reasonable reference points on how we establish the radius, if we're going to call it that, for the discharge point, the standalone discharge point. I would suggest that establish a half-mile radius for the outfall. And so that would capture just two requesters, Richard Crow and Robert Scott Teges. So I would propose that we grant their requests and deny the remaining 17 requests. And colleagues, I know I've covered a lot of ground there and kind of laid out in detail some analysis based on this novel fact pattern that's in front of us. And I'm going to pause now, and I'm interested to gather your observations. So, Commissioner Lindley, how do you see it?
I am mostly in agreement. I kind of lean more towards the 16 non-riparian requesters, and so that would include the two gentlemen you just listed, Mr. Crow and Mr. I apologize on how it's.
Yeah, and I apologize too. I called, and I'll commit the sin for you, Commissioner Lindley. I'm pronouncing it Teges, and apologies. But those are the two that
Mr.
I
Pegas,
yes.
Yeah, and apologies to him if he's listening for butchering that. So that would include excluding them. And I guess but I'm not.
Let me interrupt you real quickly. I would include Mr. Crow and Mr. Pegas in the group whose petitions were, or who requests for contested cases were granting. They live within a half a mile. They express concerns about their groundwater. So I think they're in under my analysis.
Yes. Under mine, they weren't, but I kind of have just a question, and I'm not sure who's best to answer it, if it's Mary or someone else, but and this might be better to ask in the issues portion. One of the issues I was going to recommend that we refer would be whether the draft permit is protective of groundwater and drinking water in the area. And so I do want that issue to be looked at. And I guess my question is the only way to get that issue looked at by including potentially maybe those two gentlemen, or was that issue raised enough in other comments that it would be covered? Because I don't, if both of you are in agreement that those two gentlemen should be included, I can get there. I can be comfortable with that. I just woke up thinking probably not from me, just to keep it cleaner in my mind. But I do want to make sure that groundwater is considered in the issues. So hopefully that makes sense. And I'm not really sure who's best to kind of confirm that. And again, if you know, both of you wanted to include them, I would still be supportive of that motion. I just came down not including the two in my original thoughts. But I'll stop there.
Yeah, let me share my thoughts real quickly, and then we'll invite Ms. Smith to share her thoughts. My thoughts are the issues referred to SOA are the issues as we present them. I agree groundwater is a very relevant and material issue here, and so we could refer it over, making abundantly clear that the administrative law judge should look at any possible groundwater impacts, whether they come from the plant itself or the discharge point. I don't think excluding Mr. Crow and Mr. Pegas from the contested case hearing would impact how we refer the issue over. And Ms. Smith, I'll open it up to you to share your thoughts.
I agree. Other requesters that you have mentioned brought up groundwater and drinking water as an issue, including, for example, for Full Verde neighborhoods for clean water. So that issue is in play.
Thank you,
regardless.
Ms. Smith. Okay, sorry to interrupt. Thank you, Ms. Smith, and Commissioner Lindley. That raises just another observation that I'd like to make, and that is that whatever we do with these requesters who are within a mile and a half of the discharge point, but not close to the treatment plant itself, this really boils down to whether they will be referred over as parties to this contested case. But because the requesters whose who will be referred over already did a very complete and thorough job in identifying issues. This won't make any difference in which issues are referred over. So, if that helps.
It does. Yeah. No, I'm glad. I kind of figured that was the answer, but I'm glad that y'all addressed them that way. That is helpful for me. So, I'll just kind of leave my comment for now as to me it's not worth a full-on debate whether or not Mr. Crow or Mr. Pegas should be included. I kind of fall on the side of no, but if both of you are in agreement that they should, I can get there and support a motion.
Well, why don't we hear from Commissioner Janeka and then see where that takes us?
Put it on him.
Yeah, y'all really boxed me in the middle. This is great. I am very sensitive to the point that I think Commissioner Lindley is making in that, or suggesting, implying in that it may be appropriate to deny standing for any requesters due to their location in relation to the outfall discharge, because that is treated water. It is materially different. And I appreciate the analysis trying to use the analog we find in our TLAP rules. This is a very different activity than land application, but at least that does give us some common frameworks with which to approach that question. However, on the onset of this issue, that this morning when I came to the meeting, I think I was more inclined with the chairman's thinking in terms of splitting the difference a little bit. I think the half-mile radius rather than a full mile better reflects the very conservative standards with which the outfall must meet in terms of actual water quality. I think there's a much reduced likelihood that there could be direct impacts, especially since none of the requesters are riparian. They're not directly impacted. They're not directly on that water route, the discharge route. However, I do need to note, or I feel some need to point out that there is some sensitivity to the location of the site in regards to the Edwards Aquifer Recharge Zone, and perhaps acknowledging that sensitivity by granting some of those requesters relative to the outfall rather than the treatment plan itself could be an appropriate acknowledgement of that. I don't think that it makes a big difference either way. Frankly, I note that the Belverde Neighborhoods for Clean Water request did raise a pretty broad array of issues, so we should be able to assert or direct SOA to look closely at groundwater without including these two individuals as affected parties. I don't know if my thinking moves either of you either way, and if not, if you're just asking me to pick, I think I could. But I'll stop. I'll pause there, see if y'all have any questions for me and my analysis for my thinking of it.
Thank you, Commissioner Janeka. I agree with your analysis. I'm not going to be persuaded to deny the request of Mr. Crow and Mr. Pegas. I do appreciate that the TLAP rules describe a different activity. It's not a perfect analog, but just kind of weighing all things, I do think it's important to refer those requests.
I think I'm comfortable moving in that direction. Yeah.
Commissioner Lindley, are you all right with that result?
Yeah, like I said, not to be completely redundant, even though I'm about to be, I fall a little bit different on it, but it's not, it's such a significant part of the state that I completely can appreciate the interpretation y'all come down on, including them, and I probably won't make the motion, but I can be supportive of including those two at the end of once we get to a motion, if that's where we go.
Okay. Commissioners, I appreciate that. I think we have some understanding of where we stand on the parties, and let's not belabor that anymore and instead turn to the issues. Again, for the benefit of the folks who aren't familiar with our process, we refer issues that have been timely raised by an affected person and that are also relevant and material to the application at issue. Stated a different way, the issues must be within our jurisdiction on this type of application. So, for example, we cannot consider economic impacts such as the effects on property values. We generally can't consider increased traffic or noise and those sorts of issues, even though they're meaningful and relevant to folks who would live in proximity to these permitted facilities. They are beyond our authority to address. So I identify 11 issues that should be referred, and I'll read through them, and colleagues feel free to interrupt me, or we can discuss them when I reach the end of my list. I would refer the following issues. First and foremost, whether the draft permit is protective of groundwater as well as drinking water. And I'm talking here just to flag our conversation from earlier about the effects, not only from the treatment plant itself, but also from the discharge point or any other feature of this permitted activity. I would also refer whether the draft permit is protective of surface water quality and its uses under Chapter 307, whether the draft permit complies with applicable nuisance odor requirements, whether the draft permit is protective of the requester's health, whether it is protective of aquatic plants, wildlife, and livestock, whether the application has substantially complied with all of the Commission rules and properly describes the facility and the discharge route, whether public notice was sufficient, whether the Commission should deny or alter draft permit based on need or regionalization policies as described under Chapter 26 of our rules, whether the draft permit contains adequate monitoring requirements, whether a higher than Class C licensed operator should be required, whether the applicant's compliance history raises any issues regarding the ability to comply with the permit, and that's 11. Let me pause there, and Commissioner Lindley, how'd we do with that?
I'm in agreement on all those, the 11 issues. That sounds good to me.
Commissioner Janeka?
That captures my thinking as well.
Regarding the requests for reconsideration, they don't raise any issues that were not addressed in the response to comments, in my view, so I would recommend that we deny those. We also have to provide some instruction about the time that will be allotted for the contested case hearing. Given the number of parties and some potentially time-consuming issues, I would allow the full 180 days. And we'll open it up to any other observations or a motion. Commissioner Lindley, any other observations?
No, I'm in agreement on denying the other hearing requests, including the request for consideration, and I do think 180 days is fully appropriate for this one.
Commissioner Janeka?
I think I see the pathway forward to making a motion. I'll go ahead and do that now. No other comments or issues for me if you're ready to proceed.
Great. Thank you, Commissioner. And I would just ask you to not commit the sin that I committed, and please read slowly so I can cross-reference the names and issues as you go.
Certainly will. I move that we grant the hearing requests of Bella Verde Neighborhoods for Clean Water, Benno Lux Jr., Dr. Lindsay Fitzsimmons, Julie Goss, John Lavin, and Ann Lynette Lavin. I'll repeat that entire person. John Lavin and Ann Lynette Lavin, Mary Lou Jenkins, John P. Courtney, Shannon E. Scott, Agnes Mary Clark, James Clark, and Elizabeth Clark, Adra Lee Anzalata, Scott A. Barnes, Joseph Brockman and Margie Brockman, Annette L. Lewis and Peter Lewis, Brent Winkler and Lori Winkler, Ricky D. Crow III, and Robert Scott Pegas. Move that we deny all other hearing requests and requests for reconsideration, and move that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the application and supporting materials substantially complied with all Commission rules regarding their submission and adequately demonstrated the facility's boundaries and properly characterized the proposed discharge route. Issue 2, whether the draft permit is protective of water quality and the uses in the receiving waters under the applicable surface water quality standards in 30 Texas Administrative Code, Chapter 307. Issue 3, whether the draft permit is protective of groundwater and drinking water in the area. Issue 4, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code, Section 309.13. Issue 5, whether the draft permit is protective of the health of the requesters and their families. Issue 6, whether the draft permit is protective of aquatic vegetation, livestock, and wildlife, including endangered species in the immediate vicinity of the proposed facility and discharge route. Issue 7, whether the applicant substantially complied with all applicable public notice requirements. Issue 8, whether the Commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code Section 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code Section 26.081. Issue 9, whether the draft permit contains adequate monitoring requirements to demonstrate compliance with its material terms. Issue 10, whether the draft permit should require the facility to be operated by a higher than Class C licensed operator. Issue 11, whether the applicant's compliance history for the previous 5 years raises issues regarding the applicant's ability to comply with the material terms of the permit that warrant altering the terms of the draft permit. And finally, I move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Thank you, Commissioner Janeka. I'm going to second that motion. Before I call a vote, I'm going to put a little asterisk on 180 days, recognizing that we are in the middle of a pandemic and deadlines might mean something a little bit different now. We would urge SOA, of course, to work timely on this, but also, as we're all doing, do what we need to do to protect public health and slow the spread of this virus. With that, I'll call roll. Commissioner Lindley, how do you vote?
Aye. Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
I am here. Item number 5 is the application by Inova LNG Common Infrastructure LLC for new air quality permit number 144829. The parties have been notified that the commissioners will not take oral argument but may ask questions. We have several people signed in on this item on behalf of the applicant and hearing requesters who are available if the commission has questions, and their presence will be noted for the record. And Chairman, before you begin deliberations on this item, Commissioner Janeka would like to make a statement.
Go ahead.
I don't know that this is typical or routine. We're on our second teleconference call, so I'm going to go ahead and announce this so there's no confusion or lack of clarity on it. Due to a past conversation with the applicant where I think this permit was mentioned, I'm out of an abundance of caution, I'm going to recuse myself from this particular matter, and I apologize if that puts you all in a bind. I appreciate that.
I understand. Thank you for that, Commissioner Janeka. We have a quorum, nevertheless, with 2 commissioners. Commissioner Lindley, let me lay out my analysis. These hearing requests concern a new minor source air permit for an LNG export terminal. And as I mentioned earlier, we begin our consideration of requests for contested case hearings by determining whether the requesters have met the procedural and substantive requirements. Again, requesters who are affected in a manner different from the general public and who have stated personal concerns that are relevant and material to the permit, both in timely comments and a timely hearing request, are entitled to a hearing. We have 9 hearing requesters on this matter. They include the city of Port Isabel and the city of South Padre Island, both of which failed to submit timely comments. Therefore, 30 Texas Administrative Code Section 50.115C requires us to deny their requests. That's one of the procedural requirements for being entitled to a contested case. The remaining requesters, the closest of which resides more than 4 miles from the proposed facility, live too far from the facility for the air quality impacts to affect them in a manner different from the general public. And that would very likely be true even if this were a major source of air emissions. But again, it is a minor source. So, Commissioner Lindley, I think we're compelled to deny these remaining requests as well. There was one timely request for reconsideration, which raises notice issues. In reviewing this matter, I've concluded that all of the notice requirements were in fact met. That's also the position of not just the executive director, but also our public interest counsel. So I'm going to recommend denying the request for reconsideration as well. And Commissioner Lindley, that's it for my analysis. I'm happy to hear your thoughts on the item.
I'm in agreement. I came down the same way on the people asking to receive a hearing. So I didn't find that anyone met those requirements. So I would deny all of them.
I appreciate that. I think I'm ready for a motion.
I move that we deny all hearing requests and requests for reconsideration, that we grant the new air quality permit number 144829 to Inova LNG Common Infrastructure LLC, and that we adopt the executive director's response to comment.
I second the motion, and I'll call roll. Commissioner Lindley, how do you vote?
Aye.
I also vote aye, and therefore the motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration for approval to publish and solicit comment on 23 draft total maximum daily loads for indicator bacteria, dissolved oxygen, and pH in Adams Bayou, Cow Bayou, and associated tributaries of the Sabine River Basin. The executive director's staff is here to present the item.
Good morning. When you're ready, please state your name for the record and proceed.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Roger Miranda with the Total Maximum Daily Load Program in the Office of Water. With me are Lori Hamilton with the Water Quality Planning Division and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is requesting the release for public comment of 23 total maximum daily loads for indicator bacteria, dissolved oxygen, and pH in Adams Bayou, Cow Bayou, and associated tributaries. The TMDLs cover 14 assessment units in 8 stream segments within Jasper, Newton, and Orange counties. These TMDLs are revisions of TMDLs adopted by the Commission and approved by EPA in 2007. The TMDLs are being revised to incorporate current TMDL practices such as establishing TMDL allocations by assessment unit, using model scenarios involving reductions from fully permit loading scenarios, and basing bacteria TMDLs on empirical load duration curve analysis, LDC analysis. For these reasons, TCQ has updated the TMDLs adopted in 2007. TCEQ notified watershed stakeholders of TCEQ's decision to revise the TMDLs. TCEQ representatives presented the final results of the TMDL revisions at a stakeholder meeting held on March 5th at the Sabine River Authority offices in Orange. We respectfully request approval to release the total maximum daily loads for public comment. We also request permission to make non-substantive and clerical corrections if needed before providing the documents for public notice. Thank you for your consideration, and we are available to answer any questions that you may have at this time.
Thank you, Mr. Miranda. I have none. Commissioner Lindley, any questions?
No questions. Thank you very much for your work on this.
Commissioner Janeka?
None for me. Thank you.
Ms. Smith, do we have anyone signed in to speak on this item?
No one is registered on this one.
Thank you. We'll hear from our Public Interest Counsel.
For the record, I'm Vic McWhirter. OPIC recommends approval for publication of 23 draft total maximum daily loads for indicator bacteria, dissolved oxygen, and pH in Adams Bayou, Cal Bayou, and associated tributaries as presented by the Executive Director.
Thank you, Mr. McWhirter. I want to begin by echoing Commissioner Lindley's thanks to the staff. I also thank the TMDL Stakeholder Advisory Group and the Sabine River Authority for their work on these issues. Some of it dates back many, many years. Colleagues, these draft revised TMDLs appear to be complete and appropriate and ready for notice and comment. Commissioner Lindley, do you have any additional observations?
I don't, and I can suggest a motion if we're ready.
I'm ready. Commissioner Janeka, you ready?
Likewise, please.
I move that we approve the publication of and solicitation of public comment on 23 draft total maximum daily loads for indicator bacteria, dissolved oxygen, and pH in Adams Bayou, Cal Bayou, and associated tributaries in the Sabine River Basin as recommended by the Executive Director.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Items 7 and 8 are the consideration for approval to publish and solicit comment on one draft total maximum daily load and implementation plan for indicator bacteria in Karankawa Bay in the Colorado-Lavaca Coastal Basin. The Executive Director's staff is here to present these items.
Good morning. Please identify yourself for the record and proceed with your comments.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Kerry Neiman with the Water Quality Planning Division in the Office of Water. With me are Lori Hamilton with the Water Quality Planning Division and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is requesting the release for public comment of one total maximum daily load and one implementation plan for indicator bacteria in Karankawa Bay. The TMDL covers one assessment unit in Karankawa Bay within Calhoun, Jackson, Worden, and Matagorda counties. The stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL and making decisions regarding the implementation of the TMDL. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop these documents to improve water quality in their communities. The Executive Director respectfully requests approval to publish the total maximum daily load and implementation plan for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the documents for public notice. Thank you, and we are available to answer any questions that you may have at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley, any questions?
No questions. Thanks, Kerry.
Commissioner Janeka?
Likewise, I'm fine. Thank you.
Ms. Smith, do we have anyone signed in to speak on this item?
We do not.
And Mr. McWhirter?
For the record, I'm Vic McWhirter. OPIC recommends approval for publication of one total maximum daily load and draft implementation plan for indicator bacteria in Karankawa Bay as presented by the Executive Director.
Thank you, colleagues. Again, staff, I want to begin by thanking you and all the stakeholders who worked on this, including the Texas Water Resources Initiative. And I think that this draft TMDL and the implementation plan appear complete and appropriate and ready for notice and comment. Commissioner Lindley, do you have any additional thoughts?
I do not. I think we're ready
Commissioner Janeka, absolutely. I'm happy to entertain a motion now.
No thoughts for me, and I'm happy to make that motion if unless Commissioner Lindley was just about to. I would move that we approve the publication of and the solicitation of public comment on one draft total maximum daily load and the corresponding implementation plan for indicator bacteria in Karankawa Bay in the Colorado-Lavaca Coastal Basin as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
That takes us to the enforcement docket, items 9 through 35. Item 30 was remanded to the Executive Director on April 7th, 2020. The Executive Director's staff is here to present these matters, and if you would, before you begin speaking, please state your name for the record.
And you may go ahead, Mr. Sinclair. Oh, Ms. Cordell, go ahead.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backins of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 29 and 31 through 35. The total assessed administrative penalties are $1,097,147, with $233,689 deferred, $312,808 applied toward supplemental environmental projects, and $550,650 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley?
No questions. Thank you.
Commissioner Janeka?
No questions for me.
Ms. Smith, do we have anyone signed in to speak?
No, we don't.
And Mr. McWhirter, what are your thoughts?
Yes, for the record again, Vic McWhirter, my office reviewed these items and we recommend approval of the proposed orders as presented by the Executive Director.
Thank you. I agree. And colleagues, I move that we adopt items 9 through 29 and 31 through 35 as recommended today by the Executive Director. Commissioner Lindley, any discussion? Okay, thank you. I heard a second. Commissioner Janeka, any comments before I call a vote?
No, none for me. Thank you.
Commissioner the motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 36 is consideration of the publication and hearing on proposed amendment to section 336.1310 of 30 Texas Administrative Code, chapter 336 regarding radioactive substance rules. The Executive Director's staff is here to present the item. And if you could, before you begin speaking, please state your name for the record.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Ashley Forbes, Director of the Radioactive Materials Division. With me on the phone is Amy Robinson of the Environmental Law Division. The proposed rulemaking would amend Title 30 TAC, Chapter 336, Section 1310 to adjust the Curie inventory charge. Executive Director staff requests approval to propose the publication of Chapter 336 and permission to make non-substantive corrections to the proposal package if necessary to comply with Texas Register format and file requirements. Thank you for your consideration, and we are available to answer any of your questions. Thank you.
I have none. Thank you. Commissioner Lindley, do you have any questions?
No, thank you.
And Commissioner Janeka?
I have only one question, and it's one that I think is it's a difficult question to answer because of the process that was followed for this particular rule matter. Because this was initiated by the Executive Director rather than initiated as a full rate application, I think there's a bit of a gap in terms of public transparency or the ability to see the executive director's review. And so I'll merely, I'll observe that having reviewed the particular backup materials in this item, I remain confident, having worked with ED in the past and knowing the level of review that they applied to it, that ED staff did find this rate as proposed to be fair, just, reasonable, and sufficient to maintain the financial viability of the compact waste disposal facility, which I believe tracks the rule requirements that our agency requires for these particular rates. I will only express my concern that the rate being set in this manner does pose some opportunities to do better. I'm eager to try to look at this process as a whole and try to work with stakeholders to improve it. And that's all I'll say on this particular matter. I don't think I have any questions for ED because they go to particulars that unfortunately couldn't be included in backup. And I'll leave it at that. So thank you for the chance to weigh in on it.
Yeah, thank you, Commissioner Janeka. I'll note that this is a proposal, so it will be put out for notice of comment. Hopefully that can, in some measure, go towards resolving concerns that you have about transparency and provide transparency where it may be called for. And I noted too that this is being teed up as a rulemaking and not a rate application. So there is a process, a process that includes a couple of different paths. We're taking one here, and it may in the future be more appropriate for us to take the other. But with that in mind, I agree. I think I'm ready to hear from any interested persons and public interest counsel, but I don't see anything that would be a showstopper at this stage for a proposal that will go out for notice and comment. So with that, Ms. Smith, are there any interested persons signed in to speak?
We had one individual who was signed in but indicated that they didn't wish to address the commission, and their presence will be noted for the record.
Thank you. Public Interest Counsel, what are your thoughts?
Yes, for the record again, Vic McWhorter, OPIC recommends approval for publication of and hearing on the proposed amended section of the Commission's Chapter 336 rules as presented by the Executive Director.
Thank you. I appreciate that. Commissioner Janeka, thank you again for your comments. I was going to defer to you on this matter anyway, given your experience in this program area. I'll invite you to offer any additional thoughts, and then when you're done, we'll turn to Commissioner Lindley. Do you have anything else to offer?
I don't think I have any questions or concerns about this one. I certainly agree with you, Chairman, that it's appropriate for a proposal at this time, and the public comments or feedback we receive may help instruct our process going forward. But I think this is certainly an important site, and it's an important process that the agency does participating with this rate. I think it's certainly appropriate to move forward at this time. Thank you.
Thank you. Commissioner Lindley, what are your thoughts?
I'm in agreement with both of y'all. I believe, I'm good with approving what's before us today, the publication of, and I would agree that in the future, what's before us today is a rulemaking, but it might be appropriate to look at a rate making in the future and leave it at that, because that's right now just a hypothetical. But I'm okay with approving what's before us today. And with that, I can make a motion, I guess.
Yeah, please do. Thank you.
Okay, I move that we approve the publication of and hearing on proposed amended section 336.1310 of 30 Texas Administrative Code, Chapter 336, as recommended by the Executive Director.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you are ready, please call the next item.
Item number 37 is consideration for publication of and hearing on proposed amendments to sections 293.3, 293.11, 293.14, 293.15, 293.44, 293.81, 293.94, 293.201, and 293.202. New sections 293.90 and 293.132 through 137, and repeal of sections 293.132 through 136. Implementing Senate Bill 1234 from the 82nd Legislature, Senate Bill 1987, and Senate Bill 2014 from the 85th Legislature, and House Bills 304, 440, 2590, 2914, and Senate Bill 239 and 911 from the 86th Legislature. The Executive Director's staff is here to present this item, and if before you begin speaking, please state your name for the record.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Chris Ullman with the Water Supply Division. With me is Kayla Murray with the Environmental Law Division. The proposed rulemaking would implement Senate Bill 1234, 82nd Texas Legislature, 2011, Senate Bill 1987, and Senate Bill 2014, 85th Texas Legislature, 2017, and House Bill 304, House Bill 440, House Bill 2590, House Bill 2914, Senate Bill 239, and Senate Bill 911, 86th Texas Legislature, 2019. The proposed rulemaking would amend sections 293.3, 293.11, 293.14, 293.15, 293.44, 293.81, 293.94, 293.201, and 293.202, create new section 293.90 and sections 293.132 through 293.137, and repeal sections 293.132 through 293.136, revise creation, bond, road powers, and dissolution rules for water districts, including their general provisions and annual reporting requirements. A public hearing will be offered on this proposal in Austin on May 19th, 2020 at 2 p.m. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 293 districts. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available for any questions.
Thank you. Commissioner Lindley, any questions?
No, sir. Thank you very much.
Commissioner Janeka?
No questions for me. I only applaud ED staff on being very studious in limiting the number of rulemakings to capture a large number of legislative implementation projects and or quad review repeals.
Agreed. Ms. Smith, do we have any interested persons signed in on this item?
No one is registered to address the commission on this one.
Thank you. Public Interest Counsel, what are your thoughts?
For the record, Vic McWhorter here. OPIC recommends approval for publication of and hearing on this legislative implementation rulemaking to make these changes to the Chapter 293 rules as presented by the Executive Director.
Thank you. Colleagues, as we heard, this rulemaking package is to implement numerous bills as well as findings in our quad review that pertain to, among other things, the procedures for various local governmental entities, including municipal management districts, municipal utility districts, levy improvement districts. The proposed changes appear to be appropriate to me. I think we should go ahead and put this out for comment. Commissioner Lindley, what are your thoughts?
I'm in total agreement. I think it's ready to go out.
And Commissioner Janeka, I would invite your thoughts and a second, or a motion rather.
Yeah, I certainly have, I'm in agreement across the board, and I'll make the motion that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code sections 293.3, 293.11, 293.14, 293.15, 293.44, 293.81, 293.94, 293.201, and 293.202, proposed new sections 293.90 and 293.132 through 293.137, and the proposed repeal of sections 293.132 through 293.136 as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 38 is consideration for publication of and hearing on amendments to 30 Texas Administrative Code Chapter 305, Consolidated Permits, and 30 Texas Administrative Code Chapter 330, Municipal Solid Waste, and repeal of Chapter 330, Subchapter F, Analytical Quality Assurance and Quality Control. The Executive Director's staff is here to present this item. Before you begin speaking, please state your name for the record.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Ruben Mezda with the Waste Permits Division. With me is Anthony Tatu with the Environmental Law Division. This rulemaking would revise 30 TAC, Chapters 305 and Chapter 330, to implement House Bills 1331, 1435, and 1953, and repeal obsolete requirements of 30 TAC Chapter 330, Subchapter F. A public hearing will be offered on this proposal in Austin on May 19, 2020 at 10 a.m. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 305 Consolidated Permits and Chapter 330 Municipal Solid Waste. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No questions for me. Thank you.
Ms. Smith, is there anyone signed in to speak on this matter?
No one is signed in on this one.
And your thoughts, Mr. McWhirter?
For the record again, Vic McWhirter, OPIC recommends approval for publication of and hearing on this legislative implementation rulemaking to amend or repeal sections of the Chapter 330 rules as presented by the Executive Director.
Thank you. I agree. This is a straightforward legislative implementation rulemaking to increase the MSW application fees. I think it's appropriate to move forward with this proposal, and I'm ready to entertain a motion.
I move that we approve the publication of and hearing on proposed amendments to 30 Texas Administrative Code Chapter 305, Consolidated Permits, and 30 Texas Administrative Code Chapter 330, Municipal Solid Waste, and repeal of Chapter 330, Subchapter F, Analytical Quality Assurance and Quality Control, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
And Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 39 is our public comment session. No one is currently signed in on this item, but I'll ask that the line be unmuted for a moment to give anyone who is not able to register an opportunity to speak up. Hearing none, we'll move on to items 40 through 43, which are for closed session. The Commission will not meet in closed session today.
Thank you. Before we adjourn, I'd like to again encourage everyone to guard yourselves from the COVID-19 virus. Please, to the extent you can, shelter in place, follow the CDC recommendations, wash your hands, avoid touching your face. If you're in public, maintain at least 6 feet from other people and wear a face covering. When you consider errands, necessary errands, and other vectors for this virus, please be mindful of what's really essential. The terrible consequences of this pandemic are mostly ahead of us, and we're going to soften the blow by taking good care of each other. So be good to each other. With that, the time is 11:10, and we are adjourned.